Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, outside of Fort Worth. Today's short video is about how fast you can get a divorce in Texas. This is a fairly common amongst divorce clients where people are considering a divorce in Texas. The answer here is pretty simple, very straightforward. Under the Texas Family Code, in most cases, a divorce can only be granted 61 days after the divorce petition is filed. That's going to be the standard rule. The Texas Family Code, which governs divorces, requires a 60-day waiting period as a cooling off period to give people an opportunity to consider whether they really want the divorce, because it's much easier to wait a couple of months, figure out this is not what you want to do, than it is to spend the time and money getting divorced and then reconciling and getting back together and remarrying. So the Texas Family Code says hold off for a couple of months, then you can go get divorced. It's fairly rare, actually, for a divorce to even be completed that fast, particularly if the divorce is contested. In contested divorces, usually it's months down the road before either an agreement has been reached to resolve the divorce, or for a hearing to be scheduled and for the case to go to trial. But in an uncontested divorce, it is pretty common for a divorce to be wrapped up within that 60 days or shortly afterwards, and then go in for what's called a prove-up hearing, which is a very brief hearing in front of the judge in which the parties explain to the court why the agreement reached within the divorce decree is fair and ask the court to grant it. There's an exception to the 60-day waiting period, and there's just one exception, really, and that's when there's family violence involved, and waiving that 60-day period is in the interest of the parties, particularly for their safety, to keep a spouse or the spouse and kids away from somebody who's actually employed violence against the family. And there's really two different ways that you can prove a sufficient level of family violence to justify that waiver. One is if one of the spouses has actually been convicted of or received deferred adjudication for a crime involving family violence against the other spouse or somebody else in the house. And second is if the court has ordered an active protection order or an order for emergency protection because there's a history of family violence, that can also justify the waiver. But outside of those two conditions where a court has found that, or a party has admitted to family violence, courts really are not able to waive that 60-day period. And to be even more specific, that is the only reason that a court is allowed to waive the divorce period. Following the divorce, the Texas Family Code also insists upon a 30-day waiting period before either party to the divorce can marry somebody else. Now, that 30-day period can be waived under a broader set of terms, but unfortunately those just do not apply to the 60-day waiting period. So without that family violence, the only way to really get a divorce as quick as possible is to file a divorce petition as soon as possible and get that 60-day period started.